Ang paladesisyong Petics Leader ng Tondo, Miguel Garcia. Ang Situationship Lover Intellectual Leader ng Bulacan, Mark Tristan Aro. Ang palatawang Game Master ng Cainta, Lance Altovar. Ang sabaw na Presentation Director ng Bicol, Jasmine Pimentel. Ang selosang Secretary ng Pasig, Kelly Junio. Ang banker enthusiast na Assistant Game Master ng Quezon City, GJ Ramirez. Ang OA Racer na Technical Assistant ng Angono, Kiara Maghako.
Hello Philippines and hello world! Kamusta rin ang Team Online? Magbubukas na ang pinaka-legendary na bahay sa buong bansa. Simula na rin ng malawakang pagsubok sa katatagan ng mga housemates ni Kuya. Sino-sino sa mga housemates ang mapipili at mapapabilang sa Big 4 at aabot sa Big 9? Ang mga hamon ba nila ay makaharap at malalagpasan? Yan ang dapat nating pakaabangan. Dito lang sa Pinoy Big Brother, Good Governance and Social Responsibility Edition. And this is the moment, housemates. For our Chapter 6, we have Ethical Decision Making, Employer Responsibilities, and Employee Rights. For our chapter objectives, sa aking pagbabalik. Thank you, housemates. And I'm back, housemates. For our chapter objectives, after reading this chapter, you will be able to distinguish between the two distinct perspectives of the ethics of workplace relationships, explain the concept of due process in the workplace, describe how to downsize in an ethical manner, explain the difference between intrinsic and instrumental value in terms of health and safety, illustrate an employer's responsibility with regard to employee health and safety and why the market is not effective at managing this responsibility. Explain the basic arguments for and against regulation of the global labor environment. Describe the argument for a market-based resolution to workplace discrimination. Define diversity as it applies to the workplace, as well as its benefits and challenges. And lastly, explain affirmative action and describe the 3 ways in which affirmative action may be legally permissible. In ethical decision making, a quote by Peter Scotch, hire character, train skill. Under the Ethics and Business by J. Paul Getty, the employer generally gets the employees he deserves. For our introduction, ethics in the employment context is a universal topic. The law provides guidance for thinking about ethical issues in the workplace, but these issues go well beyond legal considerations. This chapter explores areas of ethical decision-making in the workplace, remains relatively fluid, and where answers are not easily found by simply calling the company lawyer. Still in the introduction part, various ethical challenges facing the nature of employer responsibilities and the employee are addressed in this chapter. As each issue is examined, try to employ the ethical decision-making process to reach the best possible conclusion for the stakeholders. And utilizing an ethical decision-making process avoids later hurdles and removes barriers to progress and momentum.
Ethical issues in the workplace, the current environment. Ethics at work in human resource management is about relationships with others and with the company. Companies who place employees at the core of their strategies produce much higher long-term returns to shareholders than their industry peers, more than double. 50% of US workers feel strong loyalty towards their employers. Important factors for them was to feel valued by elements such as benefits and opportunities for professional growth. But 78% of those workers who experience the opposite, like unethical or uncivil behavior at work, report that their commitment to the organization declined, including their performances. There are many ways of treating employees in an ethical way in a workplace environment. Examples are treating employees well for a return. The return is harmony, productivity, or even innovation. Effective firms share common practices, all of which involve treating employees in humane and respectful ways. Managers have an impact on the emotions of their workers as do as rewards, compensation, and composition of teams. As well as treating employees out of a sense of duty is also an effective way. This approach emphasizes the rights and duties of all employees and treating them simply because it is the right thing to do. A sense of duty might stem from the law, professional code of conduct, corporate codes of conduct, or even moral principles. Defining the employment relationship. Having a professional relationship between employees is very important in a workplace environment. Ethical issues are bound to rise once a relationship is formed between an employer and an employee. To work for another person raises issues of power, obligation, responsibility, fair treatment, and expectations. Legal requirements might protect some of the employees and employers' interests, but can only go so far. The next sections cover the ethics underlying the concepts of due process and fairness that determines acceptable workplace behavior. The relationship is further defined by the application of these principles to working conditions. Issues in the follow subsections are settled from an ethical perspective by their justifications. Due process and just cause. Should employers' rights and ability to hire, fire, or discipline employees be restricted to prevent injustices? Philosophically, the right of due process is the right to be protected against the arbitrary use of authority. In legal context, due process is the procedures that the police and courts must follow in exercising their authority over citizens, and including employees. Due process in the workplace acknowledges an employer's authority over its employees. For example, basic fairness. It is implemented through due process. It demands that this or one's power is to be used justly. However, workplace bullying and other emotional abuse is a problem, especially in the service sector. This behavior directly and indirectly impacts employees.
Employment at will, or EAW, is a legal doctrine that holds that in the absence of a specific contractual or legal obligation, all employees are employed at will. This means that employers may fire employees at any time for any reason. Similarly, employees are free to leave their jobs at any time for any reason. However, there's exceptions to the doctrine. It's important to note that states vary in their recognition of exceptions to the doctrine of employment at will. Some states recognize one or more exceptions, while others might recognize none at all. These definitions of these exceptions may also vary from state to state. The ethical rationale for EAW is that it is considered an important management tool. EAW gives managers the ability to make efficient decisions that should contribute to the greater overall good. By allowing employers to terminate employment at will, managers can quickly address performance issues, adapt to changing business needs, and maintain operational efficiency. However, it is crucial to recognize that even if EAW were an effective management tool, justice demands that such tools not be used to harm other people. The right of private property, which includes the right to manage one's business, is limited by other rights and duties. This means that the freedom to terminate employment should not be exercised arbitrarily or unjustly. While the freedom to terminate employment is theoretically mutual under EAW, there is an unbalanced power relationship between the employer and the employee. Employers typically have more resources, legal knowledge, and influence, which can put employees at a disadvantage. This power imbalance can lead to situations where employees feel vulnerable and unjustly treated. The courts and legislature has created exceptions for EAW, such as civil rights laws, labor laws, and constitutional limitations on government authority into the workplace to protect employees. It's important to note that states vary in their recognition of exceptions to the doctrine of employment at will. Some states recognize one or more exceptions, while others might recognize none at all. The definitions of these exceptions may also vary from state to state. Bad faith, malicious, or retaliatory termination in violation of public policy. This exception protects employees from being terminated for reasons that violate public policy, such as firing someone for filing a workers' compensation claim. Termination in breach of the implied covenant of good faith and fair dealing. Employers are expected to act in good faith and deal fairly with employees. Terminating an employee to avoid paying benefits that are due soon will be a breach of this covenant. Termination in breach of some other implied contract term. In certain jurisdictions, implied contract terms might be created by provisions in an employee handbook. For example, if an employee handbook states that employees will be terminated for just cause, this can be considered an implied contract term. Termination in violation of the doctrine of promissory estoppel. This exception applies when an employee reasonably relies on an employer's promise to the employee's detriment. If an employer promises job security and the employee relies on this promise, the employer may be stopped from firing the employee. Other statutory exceptions. There are several statutes that provide exceptions to the EAW doctrine, such as the Worker Adjustment and Retraining Notification Act, the Family and Medical Leave Act. These statutes impose specific obligations on employers that limit their ability to terminate employees at will. Under the EAW doctrine, EAW holds in court until and unless an exception can be demonstrated. This means that the burden of proof lies with the dismissed employee to show that he or she was unjustly or illegally fired. In contrast, due process and just cause would reverse this burden of proof onto the employer. Just cause is a standard for terminations or discipline that requires the employer to have sufficient and fair cause before reaching a decision against an employee. This means that an employer must provide evidence and justification for the termination or disciplinary action. Due process issues are not limited to terminations. They arise in other employment contexts as well. Fair treatment involves fairness in areas such as promotions, salary, and benefits. Since these decisions are made on the basis of performance appraisals, due process rights should extend to this aspect of the workplace as well. The ethical questions that remain are whether this atmosphere is fair and just for all stakeholders. Due process is the right to be protected against the arbitrary use of authority. Decision makers must guard against making arbitrary decisions. Decisions should be made in light of reasons that can be ethically defended. Downsizing refers to the reduction of human resources at an organization through terminations, retirements, corporate divestments, or other means. It is often used by organizations to cut costs, improve efficiency, or respond to financial difficulties. The decision to downsize raises significant ethical issues, particularly when considering the alternatives that might be available to an organization in financial difficulty. It is crucial to evaluate the impact of each alternative from the stakeholders' perspective.
Downsizing. Negative incomes include poorer recommendation of the firm by former employees, a decline in customer service by surviving employees, an increase in error or dangerous behavior by employees, bad attitude from remaining workers. Ethics must be central to the design and management of layoff policies. The decision for downsizing should be made by representative group to consider all stakeholders' interests and earn the trust of those who will be intact. The facts should be collected and issues should be determined. Notice of an intent to downsize should given as soon as the downsizing is going to happen. Cost and benefit must be weighted in any communication decision. Identify stakeholders and identify the impact of downsizing on it. From a legal perspective, the decision about whom to include in a downsizing effort must be clearly planned. Firms should review both the fairness of their decision-making process and the consequence of that process on those terminated, and the results composition of the workforce. Downsizing impacts countless stakeholders. Health and safety. Employees have a fundamental right to a safe and healthy workplace. However, in some workplaces in our world, employees lack even the most basic health and safety protections. Those work environments have been called sweatshops. The extent of an employer responsibility is a dispute and there is a disagreement about the best policy to protect health and safety. Like work, health are goods that are valued as a means for attaining an end and also ends in themselves. Health and safety have intrinsic value in addition to instrumental value. If a person dies in a workplace accident, their lost wages would be instrumental value. And the intrinsic value of their life is irreplaceable by any financial means. If safety means completely free from risk, certainly no workplace is perfectly safe. If health and safety are interpreted as ideals impossible to realize, then it should be unreasonable to claim that employees have a right to a healthy and safe workplace. Calculating acceptable level of risk. From this perspective, a workplace is safe if the risks are acceptable. So, probability of harm for any specific work activity is equals to or less than probability of harm for similar or more common activity or activity is safe. Probability of harm for any specific work activity greater than is probability of harm for similar or more common activity or activity is not safe. Challenges to acceptable risk approach to health and safety. Treats employees disrespectfully by ignoring their inputs as stakeholders, ignoring the fundamental deontological right an employee might have to a safe and healthy work environment, assumes an equivalency between workplace risk and other type of risk when there are significantly difference between them. Improperly place incentive because the risk faced at work could be not controlled by others who might stand benefit by not reducing them.
Health and safety as market control. Supporters of the free market and classical corporate social responsibility believe that workplace and health and safety should be managed through individual negotiations between workers and employers. Workers who want better safety might accept lower wages, while workers willing to take on more risk would ask for higher wages. In a competitive market, this bargaining would lead to an efficient balance of safety and pay. The possibility of having to compensate injured workers if an employer is found responsible encourages employers to maintain a safe workplace. Challenges with the free market approach to health and safety. The free market approach to workplace health and safety has significant challenges. Labor markets aren't perfectly competitive and employees often lack the necessary information to make informed decisions. Additionally, focusing only on individual bargaining overlooks important issues on social justice and public policy. Therefore, relying solely on this approach may not ensure fair and safe working conditions for all workers. Health and safety as government-regulated ethics. Mandatory government standards help overcome market failures by using the best scientific knowledge. They prevent workers from having to choose between a job and their safety, focusing on preventing accidents rather than just compensating for them, and address important public policy issues that all markets often ignore. Therefore, government regulations play a crucial role in ensuring safe and fair working conditions for everyone. The Occupational Safety and Health Administration, OSHA, is a federal agency responsible for creating and enforcing safety health regulations in U.S. workplaces. OSHA work ensures that businesses comply with standards designed to protect workers from hazards, promoting safer and healthier working environments across the country. OSHA regulations were aimed at achieving the safest feasible standards, allowing trade-offs between health and economics. Critics suggest that OSHA should use cost-benefit analysis when setting safety standards, aiming to align with market-based goals of individual bargaining. However, this approach has ethical challenges as it prioritizes economic criteria over worker safety. It's important to distinguish this from using cost-effective strategies to implement standards which focuses on efficient enforcement rather than setting the standards themselves. Therefore, relying on cost-benefit analysis for setting safety standards can be ethically problematic. The consensus policies in the United States are well supported and justifiable. Workers have an ethical right to mandatory health and safety standards and must be informed about workplace risk. The agreed-upon policy states that as long as the risks are reduced to their lowest feasible level and employees are fully aware of them, the employer's duty is fulfilled. This approach ensures a balanced and responsible commitment to workplace safety. Rights and responsibilities in conflict. Ethical debates in the employment relationship continue, reflecting differing philosophical perspectives. First is the Kantian perspective. There is ongoing debate over universal agreement on fundamental rights and their prioritization. Second is utilitarian viewpoint. This agreement persists on determining which resolutions lead to the greatest good for the most people. And lastly, distributive justice. Arguments from both camps emphasizes fairness in distribution. These debates highlight the complexity of ethical considerations in employment, where philosophical perspectives influence discussions on rights, utility, and fairness. Advocates use ethical theories like Kantian ethics and utilitarianism to articulate arguments and insights for addressing challenges. These frameworks help in evaluating rights, consequences, and fairness, guiding thoughtful and principled decision-making process.
The global workforce and global challenges. Workers outside the United States may be subject to some U.S. laws. If they work for an American-based organization, though enforcement is cutting. In certain developing countries, workers find themselves subject to conditions that U.S.-based workers would find intolerable. Many economists argue that the maintenance of sweatshops, or what we call all workplaces with conditions that are below standards in more developed countries, is therefore supported by economic theory. It is helpful to consider the global dimensions of an ethically responsible workplace. Scholars suggest that the country universal principles should govern the employment relationship, and the ethical obligation of respect for persons should guide the employment interactions. A fundamental moral minimum set of standards exists that should be guaranteed to workers in all countries, notwithstanding culture, stage of economic development, or availability of resources. Setting a living wage is problematic because there is no exact number that one can agree on regarding the count of people who live in poverty. Non-wage benefits can provide an advantage to both the worker and the employer. For example, health checkups and the basic health services. While international non-governmental organizations suggest that voluntary standards to which possible signatory countries or organizations would go. The case of child labor. Child labor refers to exploitative work that involves some harm to a child who is not of an age to justify his or her presence in the workplace. High levels of child labor are associated with low literacy levels like HIV or AIDS, non-HIV infectious disease, and malaria. The risk of passing on poverty and child labor to the next generation increases. We should carefully review the social and economic structure within which child labor exists. On children, they may begin to work as young as 3 years old. They may also work and live in unhealthy conditions. They are also mostly required to work full-time, precluding them to education, and also forced to work in less hospitable underground professions if they are not working in the manufacturing industry. Legalizing child labor may lower the number of children who are working. The law allows employers to make decisions on any basis other than those prohibited by the Constitution, President, and several statutes. A global disagreement remains on employees' rights with regard to discriminations. Employers continue to advocate for their rights to manage the workplace and retain control of employees. Employees fear unfair treatment and loss of power. In discrimination, we have covered racial discrimination and covered gender discrimination. In covered racial discrimination is based on one's name, while covered gender discrimination refers to women often face distinct challenges, where women and men are both gender stereotyped but women suffer from different expectations. Though success and likability do not go together for women. Diversity refers to the presence of different cultures, languages, ethnicities, races, affinities, orientations, genders, religious sects, abilities, social classes, ages, and national origins of individuals in a firm. When used in a connection with the corporate environment, it often encompasses the values of respect, tolerance, inclusion, and acceptance. In diversity, other countries have federal laws reforming women sit on board, and business case for gender diversity is strong. Diversity in boards and management is associated with high return on equity.
Still in diversity, while diversity brings numerous benefits, it can also create conflicts. The presence of diverse individuals in a group can lead to tension and anxiety. Tensions may arise from the nature of the work itself or from additional challenges such as cultural differences. These tensions can manifest in various areas within the workplace. Integrating diverse viewpoints into a pre-existing corporate culture is a significant concern. Misunderstandings based on culturally based standards can lead to prejudgments. So, promoting multiculturalism and diversity in the workplace can educate and encourage positive diversity-related outcomes, while ignoring diversity can result in high costs, including lost productivity and potential legal liabilities. Affirmative action involves balancing employer and employee rights, raising questions about fairness and whether individuals have a right to specific jobs. Efforts to promote diversity may be perceived as reverse discrimination. The ethical issues surrounding affirmative action include ensuring non-discrimination against protected classes and addressing past discriminations through proactive measures. Affirmative action can arise through legal mandates or the Executive Order 11246, judicial requirements to remedy past discrimination, or voluntary plans. Legal constraints ensure the policy does not infringe on the rights of the majority of the employees' rights or create an absolute bar to their advancement, set aside any position for women or minorities, and may not be construed as quotas to be met or alter legitimate employee expectations. These measures are intended to be temporary to achieve a balanced workforce. Critics argue that affirmative action can create resentment and harm workforce morale by punishing current individuals for past wrongs. The Supreme Court addressed this in a 2003 case involving the University of Michigan Law School, ruling in favor of the school's admission policy while also upholding a state constitutional amendment banning affirmative action in public university admissions. Accessibility content, text alternatives for images. Using the figure 6.1 in calculating the acceptable level of risk using this text alternative, we can determine the safety of a specific work activity through comparing its probability of harm to that of similar, more common activities. In simple terms, if the risk is equal or less than the common activities, it is considered safe, while if the risk is greater, the activity is not safe. This is the end of our presentation. Again, this is Group 1 and thank you for watching.
Sikat ang Pinoy